If your status has expired and a marriage-based filing is pending, a court notice can show up first, and that changes the rest of the case quickly. For example, if you overstayed a student visa, then filed a marriage-based adjustment application, and a couple weeks later got a notice to appear, you may already be in removal proceedings before USCIS finishes reviewing it. What that means is urgent. The government has started removal proceedings, and that changes which agency can decide your I-485 and how the case moves forward from here. The next steps become technical fast, and the filing order can affect whether you keep eligibility for residence with USCIS while it moves forward. That is why you need to understand the consequences early, because skipping the interview or missing the notice can narrow your options fast. Usually, USCIS loses authority over the I-485 once removal proceedings begin, but it can still decide the I-130 family petition unless the top of the notice lists you as an arriving alien in that box. That arriving alien box matters because many students who overstay do not receive that label, and their notices usually say they were lawfully admitted and are removable for the reasons listed in the notice. Even so, you still need to attend that interview if USCIS schedules it promptly. You should not ignore the appointment simply because removal proceedings have started, since doing that can hurt your case and create unnecessary problems later for you. At the same time, the chance of custody action remains low. Still, anyone with criminal history should be especially careful and get legal advice quickly. If this is your situation, you need case-specific help from a lawyer, not general online guidance, because the details matter a lot here in immigration court. This is general information only, not legal advice for any individual case today. If you need assistance, you can schedule a consultation through the link. Just click the link in the description below. I will discuss your case with you directly. At this point, you have a notice to appear and both petitions are pending, and the clock is now moving inside a much tighter procedural window than before. It is crucial to get the I-130 approved quickly because that petition is the foundation for rest. For most people in this situation, the path that still leads to residence is adjustment of status in removal proceedings, provided there is an approved I-130. That is why a strong interview record matters, since delays or doubts can slow the process and complicate your defense greatly. So if filings are pending and USCIS set interview dates, that is actually a good sign, because at that interview the officer can review the marriage evidence, and if the relationship is genuine, approve the I-130 fairly quickly afterward. That speed matters because it can keep the case moving before court deadlines close. Because of that, you want the I-130 to be as strong as possible before you go to that interview or any review. If they are not convinced the marriage is real, the I-130 could trigger a second interview, a Stokes interview, or a home visit. That kind of delay can make it hard to get the I-130 approved fast enough to protect you effectively against removal, which is why the first interview matters so much when a case is already moving on a tight schedule in immigration court. If the interview goes well, the officer should approve the I-130 and will often administratively close the I-485, which means the officer cannot make a decision on it because jurisdiction has shifted once the case moved into removal proceedings, and the notice was not listed as an arriving alien on the notice itself at the top. In that situation, you would take the approved I-130 to immigration court, show the judge, and say you entered lawfully, are not otherwise inadmissible, and want the proceedings ended so you can refile with USCIS later if allowed. We just did this. The judge terminated proceedings right away in that case after reviewing the approved petition and the lawful entry. Now we will file a fresh I-485 with USCIS right away today. If USCIS closed it, ask to reopen. But in practice, those requests often get ignored anyway. After 2 or 3 requests, you're losing a lot of time, so it may be smarter to refile and move on with USCIS. That means paying a new filing fee, but it can save time later overall. If the judge refuses to end proceedings, that can happen, especially when DHS strongly objects, although the judge can still overrule that objection there. Some newer judges are less willing to do that, and they may be more cautious when deciding whether to grant termination, depending on the facts and the government's position in the record. If they oppose, you still have a plan B. You can file directly with immigration court in that forum. That is usually a much more expensive option because the case ends with a merits hearing, basically a small trial where both sides present their views. The judge then decides the issue. That decision depends on the evidence your lawyer presents and the evidence the government attorney presents. And if you otherwise qualify and there are no inadmissibility issues, the judge usually has no reason to deny adjustment. We see these cases approved all the time when the record is clean and the relief is available for eligible applicants. The downside for most people is the price. You pay the normal fee first. Then you also pay an extra filing fee for removal proceedings, at least as I remember it from current practice. That adds up very fast for many families today. Before you even consider an attorney, you're often looking at another few $1,000s to the government, and that can make this route hard for many people to afford in practical terms right now. Keep that in mind if you are choosing among options, because the most important thing in removal proceedings is getting the I-130 approved as soon as you can before the court moves to the next stage. Otherwise, you risk. If you only have a standalone I-130 pending, USCIS can take 18 months or more to decide it, and the immigration court may move ahead before that happens. At that point, you may be forced to rely on a weaker defense. If you otherwise qualify, that weaker option might be asylum, Form I-589, for someone who fears returning to a home country, and that is always a gamble for applicants. You really want the approved I-130 in place before the judge sets the final court date, or before you reach it, so the judge can either end proceedings or let you use adjustment of status as your defense. This discussion does not cover inadmissibility issues like fraud waivers, which can also be requested in proceedings when needed. Those filings are also expensive, and the same is true for criminal waivers, so every case needs a close review first. Very expensive too for many applicants. If you need a criminal waiver, you could run into an enforcement action at that USCIS interview while the officer is reviewing the I-130. Although some people still have no real alternative because they need the petition approved to avoid a final order in their situation right now. If this sounds confusing, I'm sorry. I do try to break down complicated immigration issues into simple language that people can actually follow without getting lost. Please comment below. If unclear, I can make a follow-up video if you want me to cover any part more carefully. Drop the topic you want next below. We do read those comments and we use them to guide future videos, because we are trying to make useful content every week on subjects that people in this audience find helpful and practical. I've aimed for 5 videos weekly lately here. The biggest favor is liking the video if this topic helped, so I know what to cover next. Or give it a thumbs down if it did not help. Either way, the feedback helps shape future topics for you. Engagement helps me make more videos people actually use, and that benefits viewers later too overall. If you need immigration help, I focus on family-based cases for close, practical guidance. That includes parents, spouses, children, naturalization, and removal of conditions, plus related petitions when families need coordinated help. I also handle some removal defense matters when they overlap with those family categories, because cases need both sides of the system at once, and timing can make a big difference in some cases. If you need that kind of assistance, click the link in the description below and schedule a consultation so we can look at your situation and talk through your options together. And I will see you next time for another video. If this helped, please like, comment, and subscribe, because that support tells me what topics to cover next and helps other people find the channel more easily over time. And it helps this channel grow faster for everyone here.